David Socolow is the Commissioner of Labor for the state of New Jersey. He's a graduate of Harvard University. Again, someone else who's overcome that liability to be with us today. I'm especially proud of David for several reasons. He and I had the privilege of working together here in Washington when he served first as my legislative director, then my chief of staff. He then went to work for Secretary of Labor Alexis Herman. He worked for the state of New Jersey's unemployment division, was the director of that division for a number of years, and became our Commissioner of Labor last summer. He is an outstanding public servant. He's an authority in this field. He's done a great job on this issue in the state of New Jersey, and I must confess some personal affection. He is fortunate enough to be married to my sister-in-law, Erin, and has two spectacular children, one of whom is my goddaughter. And we're just very proud of the work that he has done. I'm delighted he's here with us today. David, welcome. Great to have you with us.
It's my honor to appear before you to discuss this problem of independent contractors. And before I begin, I want to recognize some of the other wonderful New Jerseyans here, not only Congressman Andrews, Congressman Payne, Congressman Holt, who was here before, and even the Minority Counsel, Mr. Peretti. So I wanted just to send greetings to all of you.
We should strike the rest of his testimony.
Send greetings to all of you from New Jersey and from Governor Corzine. Companies that misclassify workers as independent contractors in order to lower their labor costs hurt their workers, hurt the public, and unfairly gain an advantage in the marketplace. And much has been said already. I will not reiterate all that's in my written testimony on how workers are in fact harmed by misclassification. Governor Corzine of New Jersey has led our state in an important initiative to protect workers by fighting independent contractor misclassification and rooting out the abuses of the underground economy. Our governor has recognized that the misclassification of employees as independent contractors, in addition to putting workers at risk and unfairly disadvantaging honest employers, costs the state millions of dollars in foregone tax revenue. And my full testimony does lay out the prevalence of this problem. Let me just say briefly that even in our random audits of this problem, 38% of employers were found to be misclassifying their workers, and much higher rates of misclassification found in certain industries. And so our auditors will tell you, and I will testify today, that this cannot possibly all be merely unwitting or inadvertent misclassification. And also, by and large, this is not the request of the employee coming to their employer asking to be treated as a 1099 contractor or misclassified. This is something done to workers by their employers. We are addressing the challenge, as I said. The governor directed me when I took office in January of 2006 to form a task force which included our unemployment insurance tax group, our wage and hour division in the Department of Labor, workers' compensation, and also our state division of taxation, which is in the Treasury Department, to identify the common areas of concern and develop a process to jointly refer cases and share information. By leveraging the resources and findings of each agency, one agency's findings can be used by the other without the need to duplicate the entire investigative process. And following up on Governor Corzine's initiative, a new law now provides that New Jersey's gross income tax law, wage and hour laws, unemployment insurance law, temporary disability insurance law, all use the same legal test to distinguish between an independent contractor and an employee, the ABC test. And again, therefore, by using the same legal definition, Division of Taxation staff can use the audit findings of our labor unemployment insurance tax auditors without the unnecessary duplication of effort. We've also begun cross-matching audit data with workers' compensation data to identify employers who are not properly providing workers' compensation coverage for their employees. And most recently, just on July 13th of 2007, Governor Corzine signed into law the Construction Industry Independent Contractor Act, which provides even stronger enforcement tools and, for the first time in our state, criminal penalties for employers who cheat their employees, the government, and their competitors by misclassifying workers as independent contractors in the construction industry. I have included in my testimony 5 recommendations for action by the Congress and for your consideration to reduce the misclassification of workers as independent contractors. The first one is, as I mentioned, we recently amended our statutes to have a unified ABC test, a strong test to determine the employer-employee relationship and whether or not an employee is in fact an employee or an independent contractor. We recommend that the federal law should also use that test. The second recommendation that I made is to enhance collaboration. And I want to say particularly, we heard the testimony earlier of the Federal Department of Labor Wage and Hour Division, that they are still thinking about whether or not to implement the GAO's recommendation that they refer potential cases of misclassification to their sister agencies. In this regard, I want to urge that they stop thinking and start actually referring those cases in all cases. If not to the IRS, and they made some points about whether there might be a chilling effect of referring to the IRS, then at a minimum to their sister agency within the Department of Labor, which is the Employment and Training Administration, which has jurisdiction over unemployment insurance, because we certainly in the state UI agencies could use those referrals to collect unpaid taxes and contributions to the UI trust funds. And certainly then in states like New Jersey, where we're sharing all those referrals, we could use them to collect state income tax. We could use them to ensure that wage and hour division rules were followed. By increased data sharing, joint enforcement efforts, unified definition of the employer-employee relationship, and a collaborative approach, you really can bring a broad array of resources to bear on this problem. Another comment that I had made related to the safe harbor provision, we certainly think that it is well past time to reform that provision, which really in the IRS test lets a lot of employers get away with misclassifying their workers. I also want to just say about the comment that was made by the U.S. Department of Labor Wage and Hour Division mentioned
Mr. Socolow, can you, somebody will ask you that question.
Sure, absolutely.
We're actually going to have votes in a few minutes, so we get, even if you're Mr. Andrews,
then let me just quickly finish my final point, Madam Chairwoman, with your indulgence, is that we do believe that if the U.S. DOL expanded the types of unemployment insurance tax audits that could count towards the statistics, that would provide an incentive to state UI tax agencies to increase their enforcement. Thank you very much.